Good morning, everyone. Wow, that was quick. You guys are good. Well, welcome to our special seminar. It's a timely seminar on the overtime regulations. Good news is it's not about healthcare reform. Bad news is we have one more obligation, but this is a good one. I think it's timely for a lot of us as employers, and Charla will speak to that. For those of you used to listening to Ann Vallette was not able to attend. She's our colorful commentator, and I'm not as colorful as she is, so you're stuck with me. It's a wonderful day today. Thank you for coming on a Monday. It's June 13th. Thankfully, it's not Friday the 13th. Because that's really bad news. For those of you who are new to CGI or considering CGI, we are an employee benefits group. We do much more than employee benefits. We now are called CGI Business Solutions because we offer a multitude of services to our clients. We are trying something new. It's a live stream through, oh, that's because yours is on. There we go. We're doing a live stream through a YouTube channel. Who would have known that CGI actually has a YouTube channel? Didn't know that. It's new for me. So we do have a camera over here, so I would ask for you to keep your conversations kind of down to a dull roar and turn your cell phones to a silent mode because this way the people on the live stream can hear. You are not being recorded. This is live. So the attendees that are listening to us live are going to be able to ask questions as well. So don't worry if you ask a question. As we always say, what happens in this room stays in this room. I'd like to say Vegas, but there's no alcohol being served. Anyway, I'll be sitting up here because as questions come in, I will be monitoring that. We recognize, and the reason for the live stream is we have individuals, clients all over New England, and many times they just physically can't get here. There's something great about being live, though. You get access to the food and all the goodies that we have. So we still encourage you to come to our live events, but we did recognize there are people outside of this area that weren't able to attend. This gives them that opportunity and still being able to receive credits, which I'll speak to later. I am so pleased and honored to, and I begged Charla to speak for us, so thank you, Charla. I did beg her, and I owe her big time. So I thought many of you would know Charla because typically when someone asks, a client calls, and they ask for something that's outside of my purview, because I'm not an attorney, and I forgot to mention who I was. I just assume everyone knows who I am. My name is Catherine Mirabili, and I'm the Director of Human Resources and Compliance at CGI. So I manage the HR Support Division and as well as COBRA to make sure that we're in compliance with our COBRA administration component. And so I apologize for not saying that. But Charla is an employment attorney with MCLANE Middleton. I don't know what happened to Graff and Ralston, and they're gone. Sorry. So MCLANE, it's modernized. Kind of like the other law firm that dropped a whole bunch of people from their names too. Yeah. So Charla, that's the new thing. So Charla is the director of the litigation department as well as the chair of the employment practices group. And you would have thought I would have known this by heart. But Charla, you may know Charla because I mention her name a lot when people call me and say, hey, I have a question that goes outside of my area of expertise. And what I do say is like, please call Charla. This is Charla, so if you've never met her, now you have. So Charla does a lot for employers. She's heavily involved in so many areas, and I have to read some of it, but she does assist employers with labor audits. She's been through many of them, preparing personnel policies, minimizing the risk in hiring and discipline and the termination of employees. Those are never good, right? She conducts management and harassment training. She does a great job of that. She does training in a lot of areas, so it's not just limited to that. Her litigation background includes practice in the state and federal courts, and she's done it in front of numerous state and federal administrative agencies, such as the Department of Labor, our friend, New Hampshire Commission for Human Rights, Massachusetts Commission Against Discrimination, or MCAD, as I used to lovely call them, and the Equal Employment Opportunity Commission, the EEOC. She's admitted both in New Hampshire and Massachusetts. Just call her if you need her, and she'll be here after, not for too long because she's so busy. On a personal note, for those who don't know her, Charla is an avid Red Sox fan. Go Red Sox. She's an aerobics instructor, at least she used to be. She's a runner and a cyclist. She's a golfer, and when I mentioned I owed her, I actually owe her a round of golf, so I owe you, Charla. And like the rest of us, one thing may not know, she enjoys an adult beverage after 5:01. So with that, on a serious note, Charla. Well, of course, and Mai Tais, did I hear that? So anyway, but on a serious note, Charla is a wonderful employment attorney. She brings a practical approach to employers, and again, that's why I highly recommend her and her law firm. So with that, without further ado, I'd like to introduce Charla Stevens.
Can I turn this on now?
You can turn it on. Let me turn this one off.
There we go. Test, can you hear me? Can you hear me now? All right, there we go. That's better. So good morning. Thank you for that lovely over-the-top introduction. I don't know how come the people are standing in the back. You're scaring me. Is that the staff of CGI? Or
Yes.
Okay. You guys don't get to sit. Like, why are those people standing? So one thing I would like to do is encourage you to stop me and ask questions, although hopefully the questions won't be too difficult. This is a topic that we have been chatting about for a while now, and Catherine and I actually talked about, I don't know, like maybe a week before the new regulation came out, and she said, will you do a seminar? And I said, sure, we can talk about what the new regulation will probably look like, and then lo and behold, it came out, so now we know. We have a group of about 12 attorneys in the MCLANE Middleton Employment Practice Group, and about 6 of us are what we are now calling the FLSA Task Force, who are working, we're all working together on a plan to help employers implement the changes ahead. So I would be interested to hear from you folks as we go through the slides today and the presentation, how some of your workplaces are affected. I know some stories, and I know some of the ones that are not being affected, but I will be interested to hear about particular scenarios. So I'm going to start with, yay, it's working. A little bit of background as to where it all started. So the Fair Labor Standards Act, the FLSA, it's the National Wage and Hour Law, and it was enacted in 1938. So the first thing it did was to establish the federal minimum wage, which at that time was 25 cents an hour. And so one thing you will know as HR professionals and business owners is that the minimum wage has gone up from time to time as circumstances have dictated, like cost of living and market rates. And the same thing has happened with the salary threshold, although not nearly as frequently as the minimum wage. So the other thing the FLSA did, the other big thing, is provide for overtime pay for workers. And FDR called it the most important New Deal legislation after Social Security. So what does the FLSA do? The overtime protections provide that non-exempt employees will receive overtime pay 1.5 times their regular rate of pay, and I'm sure you know that regular rate of pay can be a tricky concept, for all hours they work in a week over 40. And exempt employees do not receive overtime. So employees who are exempt under many, many different classifications, I mean, you know the standard ones: administrative, professional, computer, outside sales, executive. There are others, like employees of retail establishments, like who work on commissions, like employees of car dealerships. So there are many different exemptions. But the big ones that we're talking about now these days are what's called the white-collar exemptions. So the individuals who are exempt under those particular classifications are exempt from overtime and also from minimum wage. So why do we call them the white-collar exemptions? And I think this is helpful background because there's a lot of rhetoric around this topic. And coming up with the white-collar exemptions was the idea that there were certain people in the labor force who were highly compensated, who were of a professional or executive level where they had the ability to negotiate their own terms and conditions of employment. So they were a higher or different class of workers than your average individual hourly paid worker, who was seen to have more of a need for a law to govern how much they needed to be paid. And in addition to the white-collar exemptions, as I said, there are some of the others. But we're going to focus today primarily on the white-collar exemptions, and we're going to talk a little bit about the sales, outside sales exemption, because I think that's an important one. And one thing you'll hear from me a few times today during the course of this discussion is that as annoying as this change may be to some of you, this also presents an excellent opportunity to correct some of the sins of the past. There are many employers, I would say, because many of them are my clients, who have been making classification mistakes for a long time. And when you have a change in the law, what a great opportunity to say, okay, we're going to fix the problems, and hopefully we won't have to have a look-back period where we have employees telling us that we owe them 3 years of back pay for overtime that they weren't paid. So in order to fall into one of the white-collar exemptions, there are 3 components of the test. One is that you have to be paid on a salary. Other than the computer exemption, you must be paid on a salary. And that salary currently is at a level of $455 a week, which is just over $23,000 a year. And you have to then meet the duties test, which is that you perform executive, administrative, or professional duties. So if you don't meet the salary test, you don't even need to go to the next level and ask those questions about duties. There's also, I keep checking to make sure it changed because I'm always afraid of what's going to happen with technology. There's another level of highly compensated employee where an employee is, if they're paid a total annual compensation in excess of $100,000 on a salary or fee basis, they perform office or non-manual labor, and they also meet the duties test, then they're automatically exempt as a highly compensated employee. So in other words, they have to meet some of the duties in the duties test, but it's not as strict an analysis given the fact that they earn so much more money than your average employee. And that's another one which is changing, but the current level is $100,000. So then what happened? So in March of 2014, President Obama looked at the issue and directed the Secretary of Labor to propose revisions in order to modernize and streamline the regulations. Now, he didn't provide any particular guidance other than the fact that he wanted them to look at the salary test because 23,000 plus was considered to be a pretty low threshold for the salary test, considering the fact that these hadn't been looked at since 2004. And I'm guessing that some of you were around in 2004 when we went through the changes, and at that time there were changes to both the salary test, and guess what? It doubled at that time, and also the duties test. So back in 2004, the salary threshold was something like $255 a week. But they also changed the duties tests back then. And my office in particular was one that was impacted because back in 2004, they determined that paralegals were no longer under the professional exemption because they came under the supervision of an attorney. So there were some significant changes to duties tests that happened back in 2004. So President Obama said, it's all open for discussion, salary, duties, everything. Department of Labor, go at it. Run a comment period, do some investigation, and determine what changes should be made. And so we've known since 2014 that something was going to happen. We just didn't exactly know what. So what are the changes? The salary level threshold is $455 a week. Important to note that that's below the poverty guidelines for a family of 4. So this was considered to be a significantly low salary threshold, and only 12% of U.S. workers actually fell below that threshold. In 1975, 65% of workers fell below that level. And the real focus was we want to help workers who are in certain businesses, industries, where employees have tended to be paid particularly low wage rates, salary rates, and then work a lot of hours. So what are they? They're retail, they're service industries, and the example we've put up here is the manager of the McDonald's, Burger King, Wendy's, who has a very low salary, works 60 or more hours a week, no overtime, and this results actually in an hourly rate, if you calculated it out, as less than the minimum wage, which is actually less than the people that that person is managing are paid. So that was the focus or the reasoning behind it. Let's look at these industries, these individual workers, and let's propose a more reasonable or modern salary threshold. So what did we get? The salary level test was increased up to $913 a week, which is just over $47,000 a year. And if you remember the proposed regulations that came out, I think back in the, well, I don't know when it was, probably early in the year. The months have kind of blurred together. It was actually at a little bit higher than that, where it was just over $50,000. And then there was this comment period where they received hundreds of thousands of comments from private businesses, from retail, from service, from nonprofits, from organized labor, from workforce organizations, commenting on the proposed regulation. The proposed regulation touched only salary test, did not at all touch the duties test. And that was a little bit of a surprise because the thought was, I know potentially some of you have struggled with it, some of the duties tests are a little confusing. And they're a little bit subjective, and we're going to go over those as a review. But so there was some surprise that some of us were hoping that there would be some clarification on the duties tests to make it more easy to determine whether or not somebody is classified properly under the duties test. So they didn't really give us any help there. But they stuck with the things that were easier for them to change. Up to $913 per week for the salary threshold, and it's salary or fee basis. It's not any other compensation. They also increased the compensation level for highly compensated employees to $134,000 per year, or a little over $2,500 a week. What other changes? There's a mechanism for automatically updating the salary levels for standard employees and for highly compensated employees. So what does that do for us? Hopefully it avoids another, let's wait 10 years and then have the salary threshold double. Instead, let's do it every 3 years, again, based on things like cost of living, market, and it is anticipated that employers will get about a 120-day warning as to what the new salary thresholds will be. So there'll be some opportunity for planning. Also in response to the comments, because a lot of employers were saying things like, gee, we like to incentivize our employees. So different from the proposed regulation that came out, they have now added an allowance for up to 10% of the employee's pay to be paid in bonuses, commissions, non-discretionary bonuses, not Christmas bonuses, or commissions, that type of non-discretionary based on performance payment, as long as it's paid quarterly. So it's not somebody, earned $40,000 a year, and on December 15th, we're going to make a decision to pay them a bonus in order to get them up to the salary level. That bonus or commissions or whatever it is has to be paid quarterly so that the employee has the ability to access their funds and to be at that $47,000 level throughout the year. So exceptions to the salary level test. Teachers, so if anybody here works for either a private or public school, a bona fide teacher, certified teacher, college professor, the salary level test does not apply to them. Lawyers, of course, doctors, outside salespeople who have their own test, and we're going to talk about that because that's one of my pet peeves, and I take every opportunity to harp on that one. And then computer employees who are computer workers, professionals who can be paid by the hour, but who need to be at a certain level of expertise. So they're programmers, people who write code. They're not people who work the help desk. They're not people who troubleshoot. They're not people who install computers for people. They are high-level computer employees with a good high level of professional expertise in that area. And the reason that it was hourly is because in that industry, employees do tend to be paid hourly and at significantly high hourly rates. You know, you'll hear computer employees being paid, you know, anywhere between like $50 or $60 per hour worked. So they are also exempt from overtime. So the duties test, as I said, no changes, but, and this is a big but, and this is where we have our opportunity to correct things. Many companies are currently committing errors in this area, and the changes in regulation are giving us a great opportunity to correct those mistakes. So what kind of mistakes are we seeing? We're seeing people that are being classified potentially under the administrative exemption that don't belong there, that don't have the significantly high level of discretion you need in that area. We're seeing people characterized as executives who really are not executives. They're kind of lower level managers, supervisors, foremen. So that's why I think it's important for us to do a little review of the tests. So the executive exemption. In order to qualify under the executive exemption, employee number one has to meet the salary test. So right now it's $455, it's going up to $913. Step number one. Don't meet that, go no further. Or, as we're going to talk about strategies, maybe you're going to raise their salary. Their primary duty must be managing the enterprise or a customarily recognized department or subdivision of the enterprise. So what does that mean? The enterprise could be they manage the entire business. They're the CEO. They are the plant manager. They manage the entire manufacturing facility. They are a branch manager of a bank. So they manage an entity. And in some places, they're a store manager in retail. They're the hotel manager of, you know, the Mount Washington Hotel, the general manager. And their primary duty has to be managing the enterprise and managing the employees. So how do you manage the enterprise? You make significant business decisions regarding the future of that organization, the supply chain, what type of advertising, marketing you do. So it's a high level of management. As contrasted with, you know, the line lead in a manufacturing facility who primarily does work alongside the employees. And there was big litigation in Massachusetts over the Starbucks store managers. Were they managers or were they employees such that they qualified to share in the tips? And the argument that Starbucks was making was, no, they're managers. But they were making the coffee along with everybody else, waiting on the customers. So the court in that particular case said, no, they're not executive managers, they're employees doing the same work. Their primary duty is not management. Their primary duty is serving customers and kind of making sure the workflow goes properly. So not an executive. Well, let's back up for a second. Then the other piece of it is that you've got to manage the employees. So you have to customarily direct the work of 2 or more full-time equivalents. And where people get into trouble here is they say, oh, he manages 2 employees, so he must be a manager. Well, is the primary duty managing the enterprise? And then what does it mean to manage employees? Authority to hire and fire, or have your opinions in that area given considerable weight? Make decisions about people's advancement, compensation, not just scheduling the hours they're going to work, but really directing the future of those employees. So significant authority over the people that they're managing. And that one I think is actually one of the easiest because it's pretty objective. Then we get to the administrative, which I think is the most subjective and the most difficult. So number 1, meet the salary test. Great, we've got that one. Primary duty. And what does primary mean? It doesn't necessarily mean more than 50% of the time. It means that is your significant duty. You might do some other ancillary stuff to help out once in a while, but for the most part, managing or whatever it is your primary responsibility. So primary duty must be office or non-manual work. So you can't use administrative exemption in an area that's different from that. And that administrative work has to be directly related to the management or general business operations of the employer or a client or customer of the employer. So who's that? That's your CFO, who maybe has no staff, but manages your budget, makes significant recommendations concerning the finances of your company, a major issue. It's your director of human resources, even if that person doesn't have a staff that they're managing. They're at a high level, they're making significant decisions. They have the next one, exercise of discretion and independent judgment with respect to matters of significance. So something like the budget, something like hiring and training of employees. So who doesn't qualify? Certainly not your administrative assistant or your receptionist, but probably not clerical people. Not your accounts payable, not your accounts receivable, not your payroll manager. Anybody who's doing things that are more what I would call rote, without a lot of discretion. You know, if there's somebody who's reporting out accounting, they report your QuickBooks out. They give you, submit reports to management. If they're not making recommendations and decisions or interpreting the data, then they're probably not at a high enough level. So these are matters of significant business discretion. And you're all looking at me like, stop saying that. Don't shoot the messenger. Then we got my personal favorite, the professional exemption. You meet the salary test. The primary duty has to be the performance of work requiring advanced knowledge, predominantly intellectual in character, requiring the consistent exercise of discretion and business judgment. It has to be in a field of science or learning, so college professor, lawyer, doctor, CPA, architect, engineer, somebody who has a specialized degree of some type, and customarily acquired by a prolonged course of specialized intellectual instruction. So it doesn't necessarily have to be an advanced degree, but having a bachelor's degree doesn't do it either. So is it in a field of special expertise? And they're also, under the professional exemption is the creative professional, which could be entertainers, somebody who performs in a band, artists, but for most of us, we don't usually end up in that area too often. So those are the tests, the primary tests that we're dealing with where the salary test has been changed. Yep?
Can you touch base a little bit on seasonal establishments and how they are exempted?
Okay, so the question was touch base on seasonal establishments. So there are several different tests for seasonal exemptions. So starting number one, you're going to have the overlay of executive, administrative on seasonal establishments anyway. So if you have the people that are running the organization, do they meet the salary basis test? The next level of exemption is whether or not you are hourly workers. So they're not going to be salary exempt employees, but they'll be hourly workers. Will your hourly workers be entitled to overtime? And there's a couple of different places you have to look for that. You have to look under federal law and you have to look under state law, and the tests are different. Most seasonal establishments end up under the Fair Labor Standards Act, where you need to be a recreational or amusement business. So that eliminates landscaping companies, snow plowing. Under federal law, they're not going to meet the salary basis. The seasonal exemption. New Hampshire, and very small employers, and there's a test with respect to the number of months in which you earn the lion's share of your gross income. If you don't engage in interstate commerce, and there are very few businesses who don't engage in interstate commerce, or your gross receipts are under $500,000 a year, you may be seasonal. You may meet the New Hampshire seasonal exemption, and you don't necessarily have to be a recreational establishment for that. And what I call that is the mom and pop ice cream stand or the farm stand, although agriculture is different, so forget that I said farm stand. But you have an ice cream stand where you make your own ice cream. you're only open during the summer, or you only earn money in the summer, that could meet the New Hampshire seasonal. So it really depends on what kind of a business you are, and it's a complicated analysis on math. But one of the reasons that I think this $500,000 piece could be important is that there are some nonprofits that could benefit from that. And we'll talk a little bit about how these changes are impacting nonprofits. And there's something called the enterprise test, which again is another complicated mathematical analysis where some nonprofits who, for example, don't make gross receipts, they don't, they do things like advocacy or something, and they don't actually make money or charge a fee for services, they may come under a certain exemption. So there's a fair amount to, can I just ask what kind of business you have?
Ski.
Okay, so that's recreational.
It is,
And
my major question
it was skiing, by the way.
is about the 6-month
Yeah.
revenue, whether it's continuous 6 months or it can be a random 6 months.
It can be, yeah, it can be any 6 months, but it's 6 months within a year.
Right.
Yeah, yeah, and that's the 6 months he's referring to is the high percentage of your receipts have to be made within a certain period. So in most cases, probably not your year-round employees that meet the salary, that do not, they'll need to meet the salary basis test and the duties test, but your hourly employees that work at the ski areas are probably going to be exempt from overtime and are not likely, if you're talking like your ski instructors and the people who work in the cafeteria and that kind of thing, they're probably not going to be affected by this because they would be hourly workers anyway. So that shouldn't have an impact on what you currently are doing. It's your higher level people, like your director of marketing or that kind of person that you're going to want to make sure that they meet the salary test. And if you want to talk more about that, I'm happy to talk after. So who's going to be affected? U.S. Department of Labor estimates 4.2 million workers nationwide are either going to be reclassified as non-exempt and now eligible for overtime, or some of them may receive a bump in pay in order to make them meet the salary test. But what does that mean locally? In New Hampshire, the U.S. Department of Labor has estimated that it's really only 22,000 employees. So in a 1-point-something million individual state population, that's significant, but it's not overwhelming as it is in some of the other states. Massachusetts is a little bit bigger, 84,000. Maine, I think, is lower than we are. It's like 15,000. Connecticut, a little higher. The areas where you're going to see the biggest impact, obviously the largest states, California, Texas, New York, Florida. And then Florida and Texas, where you get the combination of potentially a lot of low-paid workers anyway, plus a lot of people, significant numbers. Also a number of the southern states where wages tend to be lower. In the Northeast, we just tend to have higher wages due to higher cost of living. So that's about what is expected. In terms of, and I think this analysis is really done based on the fact that let's assume everybody we're talking about has already classified properly. And this is a map, which maybe if you take your magnifying glass, you can see it, but you'll roughly see where the makeup is. So what do we do now that we have this issue that we're faced with, and we have until December 1, 2016 to get into compliance? Although all of us have been thinking about it ever since 2014, right, when President Obama announced that this was going to happen. So number one, identify the employees that are at issue. And we've got some different spreadsheets and things for doing that, but essentially what we ask clients to do is make a list of your employees. Start with looking at where the salary is lower than $47,000. So your lowest pay grades of salaried employees. And then a lot of those are also going to be jobs that are most likely already misclassified based on the duties test. So you want to look at that too. And why am I saying that there are probably where you're going to have the highest concentration of misclassified employees, because those are going to be the ones that are tended to be paid less. You're probably not paying your CEO less than $47,000. You're probably not paying, hopefully, your Director of Human Resources less than $47,000. So those are the individuals who are probably properly classified based on the duties test. But if you've got an accounts payable clerk and you put them on a salary, maybe they're misclassified, so that's what you need to look at. So look at what jobs are likely misclassified, and then look at the lower paid employees. Who's between that $23,000, $47,000 threshold? And yes, it's a big gap, but for a lot of employers, what we're finding is it's really not that many people. And so what we do is throw out the ones at the top, look at the ones at the bottom, and then you're probably focusing on a group in the middle that you really need to take a look at. So then what do you do when you've identified this group that's in the delta? Focus on how the work gets done. How many hours are they working? Are they actually working overtime? How far are they from the $47,000 threshold? So you're making a determination as to what the best move is strategically and mathematically, financially, looking at the numbers. So are you going to reclassify some of these individuals as as non-exempt, and then potentially just pay them overtime if overtime is a sporadic thing that they do? And then look at whether or not it just makes sense to increase their salary. And when we say hire exempt and hire non-exempt, it's when we're bringing in new employees, let's actually look at what are their duties and what's the best way to calculate the impact on the organization financially to come up with the best strategy for responding. So some things that we're hearing a lot about, and it's the issue of salary compression. And I can illustrate it best by talking about one of the areas where it's talked about a lot is when there's discussion of raising the minimum wage significantly. Like when some of the cities, like Seattle, raised the minimum wage to $15 an hour from 10. All of a sudden now we've got our newest employees, our lowest level employees earning $15 an hour, where the guy who's been with us for 10 years is earning $16. So what does that do to him? Does that mean that we need to give him a bump in order to fairly recognize his experience, years of service? So that's what's called salary compression, where all of a sudden maybe if you don't raise the other employees' pay, you've got a lot more employees in that same pay range. And what does that do? Impacts morale, impacts the individuals who are now having new people hired off the street that are earning almost as much as they are. And that happens both with respect to an hourly rate and a salary rate. So that's an issue to look at as an employer. And then look at other things that you can potentially add into the compensation in order to get them up. And that's the things like the non-discretionary bonuses, incentive pay, and commissions. And again, you need to be really careful about that because it has to be paid quarterly, and it's only 10% of their annual compensation. So as you prepare, start to track the hours that the employees are working, or hopefully, even though your salaried workers, if you've been treating them as exempt, haven't necessarily been tracking their hours all along, ask their supervisors, talk to people, do some research. How many hours does Jim normally work? Does he usually leave at 5 o'clock? Is he out the door at 5 every day? Does he come in on weekends? What are we looking at in terms of how people are performing their duties? So are you going to reclassify as non-exempt hourly and then say there's no overtime unless you get permission? That is what a lot of companies where there's going to be a significant number of people being changed from exempt to non-exempt are looking to try to say, okay, we need to look at some policy changes, and we're not going to let people come in on weekends unless we absolutely need the work done. What else is going to happen? Potentially some employees are going to lose some flexibility, and employers will also lose some flexibility. That is another thing that impacts morale. I mean, it happened with our paralegals. They had been treated as, professionals, and they could sort of come and go as they pleased. They didn't have to keep a time card. They didn't have to tell people when they were going to lunch or write it down on a time card. Now they do. So that gets people feeling, gee, you've treated me like a professional, and now I have to answer to somebody. And that's a morale issue that you potentially need to be looking at. Some of the things that might happen as a result is that your truly exempt people may end up taking on more of the work responsibility because the lower paid employees are not going to be allowed to work overtime. So there are a lot of non-monetary issues at play here that you really have to think about. Benefits can be impacted because the number of hours that are tracked, accrual rates could be different in terms of things like vacation time, sick time, PTO, however you deal with that. Salary bumps are going to affect things like 401k matches, pensions, if you have pensions. So there's more financial impact than just the change in pay. So those are also things that you need to think about. You may want to look at your handbook policies and determine whether or not you have a telecommuting policy. Are you going to change it in some fashion in order to make sure you can comply with record keeping? And remember, record keeping is the responsibility of the employer. So if the employee is failing to do it, that's not their problem, that's your problem. So you need to determine whether or not you need a better timekeeping system. If you have individuals who work from home or are in the field, and they were previously exempt and you now need to keep track of their time, do you need to have a login system as opposed to a paper time card in order to make sure that you're getting an accurate account of the hours that they work? Meal breaks, rest breaks, for individuals where you didn't have to worry about those things before, now you potentially do. Mobile devices, why is that up there? Anybody know why that's up there? Come on, shout it out. Checking emails at night, checking emails on weekends. Now that's paid time. And if they were previously salaried and exempt, they could check their email anytime they wanted. But now, are you going to have a system where you say they're not allowed to do that? Are you going to shut off people's access, or are you going to have people with no access at all now, no remote access, because you want to make sure that they're not checking email and working off the clock or off site? And then adjusting work hours in order to have individuals avoid overtime. So it's not a simple analysis. So let's talk about telecommuting. Can you still allow it? Sure you can. But there are going to be some different ways that you're going to have to manage it with certain employees. Either the employees who are going to be changed to hourly. So you're going to have probably some clearer policies around it and set expectations. And for professional employees, a lot of what you measure is their output of work, what they accomplish in terms of tasks, their productivity. Now you're going to have to dovetail that with also looking at the number of hours they work. So are individuals going to be able to maintain the same quality of work and the same output in terms of productivity if they can only work X number of hours? So maybe in those cases, those are the ones where you want to think about a salary bump because you'd like to keep them exempt, assuming that they meet the tests. And again, accurately tracking hours. So if they're working from home, if they're working in the field, is there a way they can report in their time accurately? So training managers. This is one of my mantras on pretty much every topic, that the people at the top are usually not the ones that are going to get you into trouble. They're the people in the middle. They're the middle managers. So they have to know what's compensable work time. They have to realize that if they call an employee at home at night and they're a non-exempt employee, that's work time. If somebody's on call and they need to come in to address an issue, that's work time. So they need to be aware of that. They need to be aware of what the company's policy is regarding overtime, because you want consistency. You don't want some managers saying, yeah, sure, work as much overtime as you want, and others saying it's prohibited. Assuming that they're bona fide managers, they're probably managing a budget in terms of what they have for payroll. So you want them to have that responsibility. Maybe there's flexibility in there, but you want to make sure that everybody knows what the deal is and what the rules are. Are there other policy changes that you need to make to fit these certain individuals who previously could come and go as they pleased and now have to at least have some accountability, not only for what they produce, but also for the number of hours they work? And what's potentially retaliation under the Fair Labor Standards Act? Because employees who either complain or bring issues to the attention of management regarding conditions of work, hours of pay, whether they're being paid properly, they're protected under the Fair Labor Standards Act from retaliation. So you can't retaliate against an employee who raises issues. And there are potential, that potential for retaliation probably doesn't come from the top. It comes from the direct manager, the supervisor, so you want to make sure that they're aware of what their responsibilities are. So how do we implement it? As I mentioned before, the issue of prestige, of being treated as a professional. There are going to be some cultural changes in certain businesses. And those are businesses who were doing it right all along and are now just going to need to make changes as a result of the salary issue. But really, I would see significant cultural issues with businesses who have sort of been doing it wrong or massaging it a little bit over the past 10 or so years. You want to make sure that there aren't any surprises. And somebody asked at one of the seminars that we did last week, when should we start talking to employees about this? And I would say now. You may not have all the answers, but a lot of people are hearing about this in the media. And there is some I don't want to say misinformation in the media, but there is incomplete information in the media. I've heard a number of people ask, so as long as you meet the salary threshold, you're not entitled to overtime, right? Well, no, you also have to meet the duties test. And I think there hasn't been a lot of conversation about the duties test. Because you're getting sound bites, you're getting little short articles that are focusing on what's being changed, not on what's not being changed. So your employees may not really understand what's happening here. One of the things that you want to be sure that you're conveying is the message that we're not looking to have people make less money. What we're trying to do here is determine what the fairest way is to implement this in order for us to continue to meet our clients' needs, to be a productive business, to make sure our employees are paid fairly. Some of you may see no change at all, employees. There may not be any difference. Some of you may see a change, but we're going to look at it in terms of how do we accurately reflect your compensation, your contribution to the business, and how are we going to pay you fairly. So you want to make sure that your managers have some talking points so that they know what to say to the employees. I recommend, staff meetings, discussions about it, so that people aren't surprised, that they get at least 30 days notice, more if you can, if they're going to see either a salary or classification change December 1. So really think about that. Do we have anybody here who's in education, schools? Okay. Hello. All right. So, as I said earlier, bona fide teachers are exempt from the salary threshold. There is also an education administrator exemption for things like deans, but most of your other employees, and we work with a lot of schools, the areas where they're having some changes that they need to look at are business offices, marketing, admissions, not necessarily the directors of those areas, but other employees. So there are some changes ahead there. Yep?
For the teachers, for something like a speech or an OT or my guidance and my nurses, that's where I'm...
Yep. So with teaching, primary responsibility needs to be teaching. So bona fide, so you're not like a child care or anything, you're a...
No, No, it's school district.
Okay, so, for certified teachers, they're obviously going to fall in there. And then anyone who has, as a significant part of their work responsibility, a teaching component. Guidance counselors are probably going to fall into a different area, but, sometimes a teacher with coaching responsibilities, or part coaching, part teaching, or, anybody whose primary responsibility is teaching, and then anybody who's an educational administrator. The others you're going to need to look at individually. So the other area where we've heard a significant amount of concern expressed is nonprofits. So we're trying to look at what are some industry-specific strategies to try to deal with these things. One of the areas with some particularly small nonprofits is to look at whether or not the enterprise exception applies to you, which is less than $500,000 of gross receipts. The tricky thing about that is that you can have an individual who's covered if the individual engages in interstate commerce. So you could have a nonprofit that's entirely within one state, does not do fee-for-service work, does not have significant gross receipts, and their employees may not come under the salary threshold, the salary exemption issue, or at least at the level we're talking about. But if you have an individual contributor who, maybe does marketing or reaches out beyond New Hampshire or whatever state you're in, then they may be subject to the Fair Labor Standards Act. So it's a fairly complicated analysis. For everything else, there's really no exceptions for nonprofits. There was some hope that that might happen because many of the more negative comments came from nonprofits about the significant impact that this would have on them, primarily because of generally lower salaries, given the missions of the organizations. But the department did not elect to put in a nonprofit exemption or exception, but there may be some very small nonprofits to which the Fair Labor Standards Act does not apply at all. So if you're one of those, it might make some sense to consult with an attorney and see if you can figure that one out to see if that may work. So you folks have been really quiet. It always scares me. So that means I'm going to make you do some work now. Okay. So some scenarios. And I actually kept these fairly simple. I'm sure you folks have some more complicated ones. So Joe's the supervisor of the grounds at a manufacturing company. He supervises the work of 3 crew members, makes recommendations for hiring, firing, promotion, pay increases for his crew. He's currently paid $38,000 a year. I want that job. I'll manage the grounds crew for that. $731 a week. Grounds crew works over 40 hours per week in the spring planting season and during snowy winters. Does he meet the salary test? No, he won't come December 1. Does he meet the duties test? Yeah, yep, he does. Hiring, firing, managing. What options does the company have? And what would you look at, Mr. Company Owner, in this situation? So you can increase his salary. Does that seem like a good strategy in this particular case? Yeah, how many hours overtime he works, how often? So what's the other option? Make him hourly. Right. And you may, if he's only working overtime during certain seasons, and only some winters, the ones that are snowy, maybe make some sense to keep him hourly and then just pay overtime. There's another option, and I personally despise this option because it's complicated, but there are some limited circumstances in which it's a good one, and it's called the fluctuating work week. Does anybody use that for any employees? Wow, okay. The fluctuating work week is good for people whose typical weeks really vary from time to time. So, some week, that individual may work 30 hours, another week, 60 hours, depending on workload. And sometimes this is actually used for paralegals and some office staff. It's tougher in some of the other areas, but what it is essentially is that employee and employer agree on a salary for 40 hours of work. So my salary for 40 hours of work is $800 a week. That's what we've agreed on. And then in the weeks that I go over that and I work more than 40 hours a week, I'm paid half my hourly rate. So it can be a less costly alternative. And the theory behind it is that both employer and employee benefit because there are some weeks where the individual doesn't work 40 hours and still gets paid the same. Most weeks when they're at 40 hours, they get the same, but if they work over, there is a little premium. So it's there for people whose work weeks really do tend to fluctuate. If the fluctuation is between 40 and 60, then that's probably not going to fly. But if there are times when it's lower, that may be an alternative. But it requires constant management. You need to be looking at it all the time, and it requires math. And it also requires that the payroll administrator or payroll company, if you're using a payroll company, knows how to administer it. But it can be useful. So scenario 2, Mary's the office manager for a dental practice. She's paid a salary of $42,000 a year, $807 a week. She's got a high level of discretion in her job, but she doesn't manage any employees. Her normal workday is 8 a.m. to 5 p.m. with an hour off for lunch. Does the practice need to make any changes to her pay? So what are we going to do with Mary? Come December 1, is she going to meet the salary test? No. So she pretty much works 8 to 5 every day. She meets the administrative exemption? Yeah, probably. Probably. She's the office manager. I mean, I would look at, is she the practice manager? Is she the highest administrative person reporting to the dentist or dentists? Or is there somebody above her? So you really want to look at her duties, but she probably does based on the information here. So what do we want to do? You could make her hourly. You could keep her salaried, but salary non-exempt. One option, salary non-exempt, but then you need to pay her overtime if she works over 40 hours a week. Doesn't look like she does that much. So what would her, how do you calculate her overtime rate? 1.5 times whatever the hourly rate, so regular rate of pay. Okay. The next one is going to talk a little bit about what the regular rate of pay is. And I think we should talk about regular rate of pay a little bit because it can be an interesting concept. So Janet's the controller at a small high-tech firm. She's the financial officer with the most responsibility and discretion over the company budget. She sometimes works more than 40 hours in a week. Her weekly salary is $800 a week, which equates to $20 an hour. Can we continue to pay her on a salary? Yeah. Pay anybody you want on a salary. It's just a question of whether it's salary exempt or non-exempt. So sure, we can keep her at $800 a week. We can bump her if we want. Let's say we keep her at salary non-exempt, $800 a week. What happens if she works more than 40 hours? Overtime. And what's her overtime rate? $30. Okay. Unless. So in the regular rate of pay, you also have to include any other forms of non-discretionary remuneration. So if there's a quarterly bonus that's based on metrics, that gets included in the regular rate of pay. So that gets weighed into what the hourly rate may be. Not the end of year bonus, not the discretionary bonus, not her bonus when she reaches 25 years with the company and we give her, a couple of extra weeks' pay. But non-discretionary pay that she's automatically going to get, that the company must give either by policy or as a result of performance, that gets factored in. One of the things that we see sometimes is employee doesn't take health insurance from the company, and the company said, you don't take health insurance with us, you have it with your spouse or from some other source, so we're going to pay you $2,000 a year as a stipend because you don't take our health insurance. That's part of the regular rate of pay. So the regular rate of pay can be have a number of different factors associated with it. But this one here is the simple $30 an hour. Okie dokie. Number 4. Joan is the executive director of a small nonprofit. She's paid a fixed salary of $500 a week, $26,000 a year. Her schedule isn't set, varies from week to week, but she usually works approximately 20 hours a week. So we see this in a lot of nonprofits where we have the part-time executive director, the part-time director of resource development. Small organization doesn't need or can't afford somebody full-time. So she usually works 20 hours a week. Sometimes, such as in the weeks leading up to the organization's big annual fundraisers, where she'll work more than 40 hours a week. Do the new overtime rules apply to Joan? Yes? Why not? So there's no nonprofit exemption. Okay, if they may be, all right, you're right, thank you, Nancy. If you're under that $500,000 of gross receipts, then. But let's assume she's over, they're in interstate commerce, they're a standard nonprofit. Do the rules apply? Yeah. Doesn't matter that she's part-time. And we've seen that one a fair amount, where people have thought you prorate the salary test for part-time employees. No, you do not. It doesn't matter how many hours they work, they still need to meet the salary test. So she does not meet the salary test, right? So what are our options with her? Salary non-exempt. That probably makes the best sense in this situation, because every once in a while you're going to be paying her some extra money because she's working lots of hours leading up to fundraisers. But for the most part, so you're going to budget for that. And it's probably not horrendously unfair that she gets paid more than $500 during the weeks where she might be working 50 hours, where she normally works 20 for the 500. But that's probably a good strategy for the small nonprofit. Oops. Gertrude. Gertrude makes $43,000 a year as a New England regional manager. She's exempt as she satisfies the duties test. Regional manager. Her duties require her to travel to other New England states, often by driving. With the change in the salary test, will the company need to worry about tracking and accounting for Gertrude's time spent traveling? Yeah. So, if you were going to leave Gertrude at $43,000 a year, now 43, 47, maybe Gertrude gets a bump if she meets the duties test, which in this situation she does, but let's say our budget is really lean and we're going to think about the alternative, which is she's either salary non-exempt or we make her hourly. So then we have to worry about the time she spends driving. So which time do we worry about? She's traveling from location to location. Yep. That's work time. Anything outside her normal commuting time to and from work. So if she's a half an hour from home base, so you get the free half hour. But after that, if she's driving for work, that's all compensable time. So you need to keep track of those hours. And that's going to be an issue. because a lot of the previously exempt employees went from location to location throughout the day. Even somebody within New Hampshire, you have 4 or 5 locations in New Hampshire, you're a bank, you're a health club, you're a retail outlet, restaurants, somebody travels among them. All that time spent traveling is going to be compensable time. So you need to factor into the decision as to how you're going to treat her pay. So let's flip this a little bit and look at Gertrude and say she's an outside salesperson. She's got $43,000 base pay plus commissions. Anything that needs to be done to Gertrude's pay?
Pay her commissions quarterly.
Gertrude's, if she meets the outside sales exemption, then she's totally exempt. No issue, because that was not one of the ones that was affected. So executive, professional, administrative, but not outside sales. So nothing changes with outside sales. So she can be paid 100% commission. She could be paid base plus, as long as she's outside sales.
Can you explain outside sales?
I would love to explain outside sales. So an outside salesperson does anybody have salespeople? Okay, all right. So outside sales is somebody whose primary duty is traveling for work. So going to customer locations, going to trade shows, visiting prospects, maybe working out of their home or out of the office, but only to do paperwork. Most of the time they're on the road, either in their car or on an airplane.
Can you
They,
define most of the time? Right.
almost, I would say, you know, you're talking like 80% of the time, like 80, 90%. I mean, that is their job, to travel. Contrasted with the inside sales. Is that what you want to talk about?
No.
Okay, what's your question?
But
Okay.
when you say 80% of your time, can you look at it as a week? So if some people travel like 3 days or out of the office 3 days, but they have to be in the office 2, like is the period of time, okay, it's not 80% of the day, it's more like a week or a month?
Yeah, that's a good question. So the question is how do you figure that 80%? Is it per time or per day? Now, 80% is just my throwing it out there. There's not actually something that cut and dried, because that would make it too easy. It really has to be if you're looking at somebody whose job is to be on the road. And if you can justify that their job is to be on the road and they report back to the office for sales meetings or, you know, to do paperwork or to get sales training, then I'm okay with that being an outside sales. I think you can justify that. My job is to get out there and prospect or to meet clients. As contrasted with the inside salesperson, who might visit customers sometimes, but most of what they do is, you know, sit at their desk with the headset, and they either take orders, or they cold call, or they prospect, and they're primarily doing it from a fixed location, whether it's their home or whether it's the office. That's an inside salesperson, and that's a person who's non-exempt, which means that they need to make overtime. They need to make time and a half for hours worked over 40. They need to keep track of their time, so they need to do time records. And I'm not mentioning this just for the fun of it. I mean, I see this one all the time. This is a real problem, where this is a group of people that's historically been misclassified. And the minimum wage means, let's say they're on straight commission and they don't earn any commission this week. You've got to pay them minimum wage for that week. You can do a true up, or a draw or something like that, but they have to take home at least minimum wage every week. And they are also entitled to overtime. So what gets calculated into the overtime? Their base, if they have a base, and their commissions. So some of these people are paid pretty well, and you end up with a significantly high overtime rate for these individuals. And that's really something that, you know, as I say, now's the time to correct the sins of the past. A complete overhaul is something that is, now a lot of companies don't need that because they've been doing it right and they have a pretty straightforward way of paying people. They're either hourly or salary, and all we need to do is look at the exemptions and the rates and how much overtime they work. But there are a lot of companies who have a lot of different ways they pay people. And so they're really gonna need to look at it. Yep.
So the inside salesperson has to pay at least minimum wage overtime over. You said though, if they're on a draw, so draw is against future commissions, not so much commissions. So
Right.
does that draw amount need to be calculated into their overtime?
No, draw amount, the draw amount is an advance on future payments. So, yes, that's not addition, what the question was, does the draw need to be calculated into overtime? And no, if that's an advance on commissions, because you only count it once. So it's part of the pay. But that's a tricky one. And you really need to focus on that one if you have. And I've talked to a lot of HR folks who have taken the opportunity to try to talk to the powers that be in their companies to convince them that this is something that needs to be looked at. So I'll say, what help do you need from us? We'll send you something scary, because the amounts at issue can be really, one of my favorite lines when I work with, primarily with the HR folks as opposed to the business owners, and it really depends on the company, is, do you need an email from me? Because I can send you one with attachments, because now's the time to fix that one. Yep?
So are you saying inside sales is not, if they do make the requirement in their salary, their base salary, they cannot be exempted even at that?
Correct. Inside sales are not exempt. Yeah, unless they have a salary over the highly compensated employee threshold, like over the $100,000 right now. But right, inside sales are not exempt. So, and there are some fields in which you could have an inside salesperson who has a threshold base salary of $100,000 or more. I mean, it does happen. And those would automatically come under the highly compensated or when they get to 134. But most of the ones we're talking about are not. They've got a base of 40 or they have no base at all and they're exclusively commission. Those are the ones that need to be addressed. Recruiters is another one. Some of them earn lots and lots of money and have a high base, so it's not an issue. But, you know, staffers and recruiters at lower levels, they're not exempt and they need to be paid overtime. So then the question is, are they working overtime? And a lot of times people in sales are, because the more you work, the more sales you generate. Sometimes not, but it's something that companies really need to look at. That's why they call me Debbie Downer. So, I'm assuming we have some folks from Mass, some folks from New Hampshire, so we're going to talk about the general state law rules because Fair Labor Standards Act is the federal law. Massachusetts Wage Act provides for overtime pay, time and a half to non-exempt employees working more than 40 hours in a work week. Same thing as the FLSA. They have about 20 different exemptions. Including the ones we've been talking about, executive, administrative, professional, but also some pretty, strange ones, like, and we mentioned child actor. So you want to look to see, if you're in Massachusetts, whether those employees meet one of the 20 exemptions. The real issue that we want to focus for New Hampshire is that, for Massachusetts is the automatic triple damages provision, and it does not need to be a willful violation for triple damages. It's automatic plus attorney's fees. So if you are being investigated by the state attorney general or a claim is brought under the Mass Wage Act as opposed to USDOL, Fair Labor Standards Act, you're potentially hit for automatic triple damages for unpaid overtime. So that's a big one. Next steps. Oh, New Hampshire, I don't have the New Hampshire slide in here for some reason, but the New Hampshire one is the same thing, time and a half. There are some New Hampshire exemptions that are different from the Fair Labor Standards Act exemptions. You want to look at that. The damages in New Hampshire pretty much track the federal, which is liquidated damages for willful conduct, which can be doubled. So that's what you're looking at both in New Hampshire and on a federal level for failure to pay overtime. So next steps, what do we do? The first thing I tell people to do, even before they make their list, their matrix, is to look at job descriptions. Make sure they accurately reflect what the individuals do for work. so that you can determine whether or not you have some past misclassification issues. Maybe the individuals do a lot more than what's on their job description and have a lot more discretion than was originally contemplated, so you may be in better shape. Just revise the job descriptions appropriately and then live by them. Because when the DOL comes in, that's what they are asking the employees. Okay, we look at the job description, now what do you really do? Do you do this stuff? Do you actually manage all these employees? Do your opinions about employee advancement and compensation carry weight? And the US DOL, when they come in, they interview almost everybody, and they interview a number of former employees. So they really do ask those questions. So as I said, if you have some past misclassification issues, now's the time to address them. Run the numbers. So what are the numbers we're going to run? We're going to look at the number of hours people typically work. We're going to look at what their pay is. And we're going to determine what makes the most sense for us as a company as well as for the employee. If an employee currently earns $700 a week and you decide that you're going to convert them to hourly, are you just going to divide by 40? Maybe, maybe not. Maybe that's not the best way to come up with the best hourly rate for that individual. You know, you want to look maybe at market. What's the market rate for that job? Maybe higher, maybe lower. If they're going to be working overtime and be paid overtime, you want to factor that in. So maybe just dividing by 40 is not the way to do it. Maybe the hourly rate is lower with the anticipation that they're going to have, you know, typically 5 to 10 hours of overtime a week. So it's more than just simple division. So you really want to look at that. You want to review and revise your policies, both in terms of accrual with benefits, the policies around things like traveling, around telecommuting, around time recording. Look at whether or not you need a new timekeeping system. It's fine to have a card that the employee fills out if that makes sense and works for your company. But if it doesn't and you need something more sophisticated, it's available, it's out there, you may want to consider that. Training your managers as to how to manage employees, how to manage the workflow, how to manage staffing. One thing that may happen is that if you've got an individual who, and I look at the retail outlets for this, if you know the managers that this was designed to help, if they work 60 hours a week, you know, maybe you hire somebody to work 20 hours a week and you've got one working 40 and you've got one working 20 and you're not paying anybody overtime. So it may mean hiring more staff to address that. Communication is going to be key, not only with respect to what the monetary impact is going to be on the individual employees, but also with respect to the cultural changes that are going to take place if people either move up or down or feel as though they're taking a step backwards career-wise. Implement the changes, start the process now. It's like kind of like when we had the mass sick leave, like we talked about it for a year and a half, and then on December 29th, everybody was calling us saying we need a mass sick leave policy. Don't wait for the last minute. This is going to be a fairly complicated analysis for a lot of companies. For a lot, it's not going to affect them at all. You know, truly, there are some companies that, you know, typically don't have employees that are earning less than that $47,000 threshold if they're primarily a kind of a white-collar office environment. But there are others that are going to be significantly impacted and may have hundreds of employees where they have to do the analysis. And then consult with legal counsel as necessary. The MCLANE FLSA task force will obviously be available, but there are, you know, employment attorneys everywhere getting up to speed on these issues and are more than willing to walk through it. We're going to have things like checklists and a spreadsheet. That's what you want to use, and you're just going to do a self-audit. You know, sit down, go through it, figure out who the people are that may be impacted, and then determine what you're going to do, what makes the most sense. And then look at the people around them. Don't forget to look at the people that are just above them and below them in pay grade, because giving a bump to certain people is going to affect the people that are just above them. And that's going to be a significant concern in terms of things like goodwill versus bad will, and how you communicate to employees. Any questions? Looks like a very prepared crowd. Yes?
I'm just wondering, people that have been misclassified and need to be changed from like salary non-exempt, do they need to have a salary revision sheet and have it signed by the employee?
Good question. So the question is, if you were going to change somebody's classification and pay in some way, do you need to give them something in writing and have them sign it? Yes. And I recommend a couple of things. Number one, under New Hampshire state law, you're required to do that and have them sign off of it. If you're not in New Hampshire, I would still do that because I think it's good practice, and you also have that documentation in place. But what we usually recommend is a letter to the employee saying, this is what we've done, you know, you're effective X, you know, there's been a change in the law, we've reviewed the change in the law, you know, effective on December 1, 2016, your classification will now be hourly non-exempt, your hourly rate will be X, you will be eligible for overtime for hours worked over 40, and you know, have them accept it and sign it like they would any offer letter. Yeah, I think that's a good idea, and I think that you know, how the message is conveyed is important.
And one more question. So it's not good enough now for someone to just log on a computer timekeeping that they work 8 hours a day. They have to have in and out now.
They've always had to have in and out. So the question is, when somebody logs into the timekeeping system, can they just log in and say, I worked 8 hours today? Unless they were exempt before, and that's what they did. But any non-exempt employee for whom you need to keep an accurate record of hours worked, that means I came in at 8:02, I went to lunch at 12:15, came back from lunch at 12:45, clocked out for the day at 5:32. It needs to be exact. You need to keep track of. That's been required for non-exempt employees all along, but again, if you've been loose on that and haven't been doing it, perfect time to fix it. The other reason it's a perfect time to fix is that if you are changing people from exempt to non-exempt, there's been a change in the law and we've reviewed it. You have much less exposure to a potential claim for back wages. When people do the analysis and find out that they've misclassified somebody now without a change in the law, there's always a risk that the individual says, hey, what about, you know, the last 3 years that you haven't been paying overtime? You know, I've got a wage claim now. With the change in the law, there's a much better ability to say, we've looked at it, we've reviewed it, and now we're changing these jobs, and they're not going to come back and say, you owe me tens of thousands of dollars because I've been working 70 hours a week, and oh, there isn't any timekeeping system that says I did it, but here's my log that I created, and it says I did. Unless, you know, the burden's going to be on the company to disprove that. So now's the time to do it.
So Charla, one other question. The DOL has an app. Have you seen that app?
I have not downloaded it, but
So that's a concern that I don't know if you can hear me, but that's a concern that employers have to consider as well, as the keeping of their own hours on that DOL app.
Right, that employees can keep track of, and some of them just keep a log. Although sometimes I've had a wage claim where I've gotten a log that looks like it was all done in the same day. But there is an app to keep track of your hours, and yeah, there is. The employee may be doing that, and then in a wage claim or in an audit, turn around and say, this is the number of hours I've worked, but it's not reflected on your own timekeeping system. Anything else?
Any other
Good
questions?
time?
I don't know if you can still hear me. I feel like my ears are plugged. Oh, good, you can still hear me. Great. So if there are any additional questions, again, you can ask now. Let's not forever hold your peace.
No.
You can call Charla, and I have a direct line to Charlotte. No, I'm kidding. She'd kill me if I said that. So thank you so much, Charla. This has
Thank you.
been wonderful, and
Thank you.
and so
Thank you
happy.
both.
Learned, I think we all learned something new, right? I know I did. I always learned something new. Thank you, thank you.
Thank you.
Thank you.
Shut this off so
Oh,
I don't,
okay. We don't
squeak you.
conflict.
There we go.
For those of you who walked in late, has everyone had the chance to put their card into our basket? It is for our raffles. We have some good stuff. We have some good stuff. We have a couple of baskets. I don't want to call them baskets, but we have a couple little nice little gift things. We have a Panera gift card, Starbucks gift card, and a generous client of ours, Gunstock, is giving away 2 zip lines for free. So you have a couple of options. So I wanted to give everyone a chance to do that. I wanted to mention there is a survey. Please complete the survey. It is something that we are required to submit upon an audit. Believe it or not, SHRM audits us, as typical, right? For those that are trying to receive their credits. There are 2, we're all laughing. How many of you are SHRM members, by the way? Okay, great. That's awesome. So if you have your SHRM certification, this has been approved for 1.5 PDCs. I think they're called professional development credits. If you have your HRCI, which is your PHR, SPHR, or GPHR, additional, it's a 1.5 general credits, not the strategic. So I wanted to submit that. Speaking of SHRM members, or actually anyone else that is here, you do have a voice. We have something in SHRM called the advocacy team, or A-team. Actually, I always call on poor Dave Twitchell, but Charla and I, and even Dave, were part of an A-team. I think, Nancy, you've come with us as well. I actually have a meeting scheduled with, we're just doing the fine-tune with Senator Shaheen, but there is a bill in the Senate. I believe there's one in the House as well. I can't remember the specifics, but the one in the Senate has been supported by, and this is it's a bipartisan issue. We have support, I believe, from both the Republican Democratic Party, but we're meeting with Senator Shaheen to talk about the impact of this new regulation on employers. We think it specifically is impacting nonprofits, but if you guys are the ones that understand the impact. So if you're interested, please contact me, because I am trying to gather a group of HR professionals. We've done it in the past and we've packed the room, and that is impactful to the senator to see so many of their constituents that actually have something to say about what's going on in Congress. So I just,
do want to hear about real impact,
Real.
life impact.
that is so true. Charlotte is absolutely correct. They love the real life stories, so they don't want to just hear all the high level from, I don't want to say from attorneys, but they really do want to
They don't
hear.
really want to hear from
They don't want to hear from attorneys, they really don't. They want to hear from, they do. So they want to hear the real stories, and in fact, one of our friends, Tina Sharby, who works for Easter Seals, is actually testifying, I believe. What is she?
testified the other day.
She testified the other day. So, normal people just like you and I actually are the ones that are being asked to tell our real life stories. So if you're considering that, you don't know how to get involved, even if you're not a SHRM member, contact me, because I'd love to add you to my group of A-team members. So I wanted to mention the survey. For those that are attending our live stream, we will be sending you the credits and the survey in email. Dee will be sending that for you. I think that was pretty much everything here. So without further ado, Dee is going to help me out. I keep saying Ann. Charla gets to be, so if you don't get what you want, it's Charla's fault.
Just like at home. Roger Goslin?
Roger Goslin?
Roger.
All right, Roger. You get to pick whatever you want. And they're all here. The one for the zip line is there. And
So you get a choice out of all 6.
And Charla, I'll let you pick the next one so we can,
No wine.
no wine. That's what he asked, no wine, or no Mai Tais. Sorry, Charla.
Kara Bouchard.
Kara Bouchard? All right, Kara. It's always fun to have the silence, isn't it?
Is everybody looking at me walking up here?
Wonderful.
Where's the name? No, on the other side, Elizabeth Eastman.
Elizabeth, right up front. All right, Elizabeth. So we have the Gunstock and those 3. Gunstock, thank you so much. One more, Charla. Three more, Charla. Three more.
Holly Fadden.
Holly Fadden. All right, Holly. Next time I'll add wine to the raffle. Put your request in now for the type and the brand. I'm actually speaking in Napa next week, in Napa Valley.
Linda Tools.
I know, Linda, I'm looking right at you, wasn't that wild? So I'll break in there. I'm speaking in California next week, and we're actually getting a tour of some vineyards, so please put your request in now, and I'll just ship them.
So you can choose one of.
Either one. All right, Linda. Yay, one more.
A lot of presents.
I know, I kind of went out today.
Nancy Trask.
All right, Nancy. So thank you everyone for joining us today. I know it was a Monday morning, it was kind of a tough start, right? But you know, it's sunny out, there could be worse things. Thankfully, you're not dealing with what my hometown is dealing with. I'm from Orlando, Florida. Yeah. So my Aunt Pat, I know you can tell I'm from the South, I say aunt and not aunt, only lived a couple of blocks from where all of that occurred. Yeah, I know. Thankfully, she's not out at 2 a.m. partying, so I had to bring humor to light. So she did say that to me as well. So, but think of the positive. This is not a tough obligation for us to get through. We've done it before in the past. So I think it's a good time for us to just refresh and remind and then educate our employers and our employees. So thank you again for joining us, and we look forward to seeing you soon.